Good afternoon, Juanita.
Hello,
How are
Mark.
you?
How are you going?
I'm being very tropical today with my
Actually, lovely.
colourful T-shirt. Well, last week, you were last time we met. You were hanging out the side of the car trying to get stop the sun from
That's
glaring
right.
in.
I was zooming down the M1 between Brisbane and the Gold Coast. So it's nice to be at a desk, nice and steady, not moving. All is good.
No, that's great. Well, the good news about today, and I know people watch this afterwards and so on as well, is that today there's people all around Queensland getting some good rain. So it's a fantastic day. A lot of people I've been speaking with today are getting good falls. So
Great. Good to
hope
hear.
it keeps up for a while.
Hmm.
So okay, so let's get onto it. The topic today is it's in regard to superannuation funds, not just in regard to superannuation funds, the taxation implications,
Hmm.
binding death nominations, all those sorts of things, all things technical superannuation, which means I'll just sit back here and let you go for your life.
Try not to make you fall asleep. But this is one of my favourite topics because superannuation, surprisingly, people don't know a lot about how it's treated as part of our estate planning. And probably the starting point is a lot of people don't realise that you leave your superannuation in a different way than through your will. And so people just think it forms part of your assets that form part of your asset pool that you leave in your will, but not necessarily so. So that's usually really quite a big surprise to people that's it requires some different attention. So I'm hopeful and I'm pretty sure that there'll be lots of new information today for lots of people.
Well, I'm sure there will be because you're a whiz at this stuff. And so, in regard to the taxation implications of superannuation, I mean, people for years have been, thinking, well, I'll put my money back into my business because that will that's my best rate of return. That'll mean when I retire that I'm going to have all this money here. But one of the things, and so I'm leading into a few issues for you to touch on, Juanita. One is the tax treatment of money inside superannuation as opposed to inside your business, number one. But what we're finding a lot with people is that when it comes time to retire or succession down to the next generation and so on, the issues that are caused by all the assets being on farm and not having any assets off farm, not having money in superannuation, for example, really creates some problems in a couple of areas. One is allowing people to be able to move off the farm and have their own life with their own money without interrupting the running of the farm. But secondly, from an estate planning point of view, when you've got one child that's going to stay on the farm, one child not staying on the farm, it means there's also going to be some assets, hopefully, if you've got off-farm assets, to be able to create some sort of fairness between the different beneficiaries. So I've probably covered about 6 different
That's
topics
all
in
right.
making that
We can
statement.
we can unpack that to use a trendy term. I think
Okay. Whoa,
it,
that's a good word. I haven't heard that one
it's a
before.
really good example of why we talk a lot about having your A team. So having your financial planner and your accountant and your lawyer and yourself, Mark,
Yep.
all on the same page. So, obviously as lawyers, we're not allowed to give financial advice, and that's certainly, not what we're going to talk about today, rather the legalities of it. And that's another reason why it's good to have that whole team in place. What I
Yeah.
thought would be useful to start with is just talk about binding death benefit nominations,
Okay.
because what these documents are is the form in which you leave your superannuation death benefit to someone. Now, it's a totally separate form. So it's a separate document that we would produce and fill in with you that sits alongside your will. So as it suggests, it's nominating the beneficiary of your superannuation death benefit. Now, that can only be a certain class of beneficiaries, certain class of people. So you can only leave your superannuation death benefit to a spouse, and that includes a de facto spouse, a child, or a dependent. And additionally, you can direct it to your estate via your executor. But they're the only category. So you cannot leave it to your siblings or your cousins or your parents or your next door neighbours or your dog and cat. So if you do, then that nomination will lapse. So it's a specific form separate to the will, and there are different types of death benefit nomination forms. So this is going to get a little bit tricky. Stick with me. So you can have, and again, it depends if there's a self-managed super fund or an industry fund, but I'm generally talking today about industry funds. You can have a binding or a non-binding nomination form. And look, this all depends on your superannuation trustee and what fund you use. So they all use different forms. Some use different terminology. Some are binding, some are non-binding. And what that means is if you fill out a binding form and you nominate who you would like to leave your super to, when you pass away, it is surprisingly binding. So you super trustee. If you're with me, Mark, you must be with me on that one. Your super trustee. So even if, for example, your MLC or your Sun Super or your Q Super or whoever it might be, have to pay your super death benefit to that nominated beneficiary, it's binding on them. If you have a non-binding form, or if you have a form that was filled out incorrectly or has lapsed, which I'll come to in a moment, then it's left to the discretion of the super trustee. Now, obviously, that opens up a little bit of a can of worms.
We don't want that.
We do not want that. We want it to go to who you want it to go to, and quickly. So what happens then is the superannuation trustee has to do some investigations, and they have to contact and find out everyone that is eligible, it's an eligible beneficiary, get them to submit what their position is and why, consider all that, then come to a decision as to who they think the most appropriate beneficiary is of your super, and then communicate that to everyone, then allow an objection period. So you can already tell it's going to go for a period of time, lots of a length of time until the people that you may want or even may not want to get your superannuation death benefit actually get it. So discretion. So it might not go to who you want to. It'll take a lot longer, a lot more paperwork and burden on the people that are left behind that you wanted it to potentially go to.
And if I can cut in, for example, someone like that, if you don't have a nominated beneficiary, it could go to a spouse that you've been separated from, but they're still your spouse. It could go to children that have spending problems and all that sort of stuff. So there's no good answer from not having a binding nomination, is there?
No, and there's reasons, absolutely, and it will come to different reasons why you might nominate a certain beneficiary over another. But a good example is a client that might have children from a first marriage, and they've left their super to their children, and they want to leave other assets in their will to their new spouse, perhaps. Now, if that isn't filled out correctly or something goes wrong, then the best laid estate planning intentions can just go haywire, and all of a sudden you have a dispute between the children from the first marriage and the new spouse, and it's a nightmare. So that's a really regular example where we need to be really clear and make sure the right documents are in place and that they are binding.
Yep.
So as I mentioned, some forms lapse. So a lot of those industry super funds have the forms that have to be renewed every 3 years. So that's when we see the terminology a lapsing binding nomination form or a lapsing non-binding nomination form.
So may I just cut in? Do you mind if I cut in and ask questions as we go along?
Ask lots of questions, please do.
That would normally be the job of the advisor to remind someone every 3 years, and the financial advisor, the superannuation fund people, or whatever. So I'm going to ask the question: how many of the financial planners and advisors are very good at maintaining that bring up system every 3 years?
Yeah, I think most are, but of course some aren't. And I think what often will happen though is, I know I'm guilty of this. Sometimes you'll get your automatic emails from your super fund, and it'll have an update or a newsletter or whatever, and it just stays in the inbox, doesn't it? You get around to it later. So often those reminders might be automated and might come through to your inbox. hopefully your inbox that's current, and you just don't do anything about it, and the nomination form lapses, and then that can cause all sorts of trouble. So look, good financial planners are always in contact with their clients and will remind them about that. But it's important to know, and if possible, make a little note of and be aware.
Sure, and that's probably a really good, as you know, with our clients, every 12 months we catch up, have a meeting, and go through a checklist of all these sorts of things. And I think it's a very important part of the whole process with your superannuation, your estate planning, your succession planning, and so on, is that you have a methodical annual review. And even if nothing's changed,
Exactly.
you have peace of mind of knowing that, okay, well, for another 12 months we're okay.
Yep, absolutely. And we say that so many times. So it's always about reviewing these documents regularly, not necessarily changing them because they might be fine, but it's all about reviewing them. I suppose another thought that just jumped into my mind is that if you experience a divorce or relationship breakdown, that is like red lights, red alarm bells ringing, that you need to review this document. Because what we will often see also is a couple that go through a separation, have a property settlement even, but they forget to change or update their binding death benefit nominations if they want to. So you might, you might have gone through that process, that legal process, or you might even have just separated and your divorce hasn't been formalised yet, or you haven't had a property settlement. If that nomination is sitting off here to the side, it might be something you want to update. So that's important to be aware of too.
Okay. That's fine.
Yeah.
Keep going. So I do have a question, but I'll let you keep going.
No.
Well, I'm going to ask for example. So today you were reviewing someone's superannuation fund, and you know who we're talking about here.
Yep.
And you asked them to send you more information because there were things that you wanted to check. What were those things that you needed to check on that statement? I mean, you had the person's name, you had how much money was involved. What were the other issues that you needed to run down on?
Yeah. So in that particular circumstance, the things that I'm looking for when I ask for a superannuation statement is obviously, the basics like the name, the details, the trustee name, the date, the amount, but also two key things in particular. The first one is usually a statement will tell me if there is a nomination that has been made. So straight away you can usually tell on most full statements that a nomination has been made, if it's binding or not binding, and who it's to. So very important sort of aspect of that. And the second part that I'm looking for is in that superannuation balance, there are different components that are taxable and non-taxable. And I'm going to go to tax shortly, but that's sort of something that a lot of people don't realise, that there are taxation implications to different parts of your superannuation. So we'll get into that in a minute, but that's another thing that I'm looking for. So that's why I will often ask is, Mark, more than just the front page or just the balance, because I want to see a little bit more detail than just that, to make sure it all complements with the right estate planning documents.
No, that's right. And the good point there for people is that on your annual statement each year, so if anyone's watching this and going, well, I've got no idea whether I've got a nomination, or whether it's binding, non-binding, whether I've made one or not, the point is if they look at their annual statement, somewhere there will be that information, won't it?
Oh, yes, absolutely.
Hopefully.
Yeah.
Hopefully.
Yeah, so don't glaze over after you go through the first page, because often there will be some very important information on the pages that follow.
Yeah, and so I'm just suggesting to anyone, if you've got your statement, or you can go and grab your statement, have a look at it. And if it says you don't have a binding nomination, or if you just have a non-binding nomination, for goodness sake, get straight onto your financial advisor and get that fixed.
Yeah, and you're not alone, because I would probably say, maybe 3/4 of clients we see don't not 100% sure of what their superannuation situation is, and who their nomination is. So that's the common sort of scenario that I would see. Now, it's important to discuss these. So if you go to an estate planning lawyer and you're talking about your estate planning, this is something that superannuation must come up, and the binding death benefit nomination forms must be discussed. And if it isn't, make sure you ask. It's so important. Now, there's no right or wrong as to who you nominate as your beneficiary. and your advisors should be giving you some advice as to who is the most appropriate. And apart from tax reasons, which I'll come to separately in a minute, there may be different reasons why you would nominate, for example, your estate. So if you are setting up some great testamentary trusts in your will, you might want to direct your superannuation to your executor and your estate so it flows through those trusts and gets a lot of the benefits such as asset protection and tax efficiency that testamentary trusts can provide. However, if I'm seeing a client that they have an estate which potentially could be contested, then we don't want it to go to the estate. So that's when on your form you would put particular beneficiary's name that you want it to go to. So it's binding, it goes to them, and that sits outside any pool of assets that can be contested. So it really comes down to the personal circumstances and has to be looked at as part of the whole estate plan.
Look, absolutely, that is a very good point, because you can pass your superannuation outside of your will. And you're absolutely right. If there's likely to be a contested will, if you're worried that someone's going to have a blue after you've gone and contest your will, fight, squabble, all that sort of stuff, direct your superannuation outside of the will and directly to someone, and that takes away the risk of that being fought over.
Another little useful tip I wanted to pass on to our listeners today is around your enduring power of attorney also. So a lot of people think, and even, back in probably the day, a lot of solicitors felt that an enduring power of attorney is just a tick and flick. It's a form you can download from the website, tick the boxes, sign it, and away you go. But you have the ability in that document to put in special terms. A term that we always put in on instructions, of course, but we would recommend is dealing with your superannuation. So what we will see often is that if someone loses capacity and their attorney is acting for them and they have a little form with boxes ticked but superannuation not addressed, then when the attorney is acting with the superannuation, the trustees don't want a bar of it. So what we recommend these days is to make sure that your enduring power of attorney has a term allowing your attorney to deal with your super. So then the super trustee will communicate with them and will deal with them. Now, there are different scenarios that can be drafted in. So we've already spoken about your binding death benefit nomination and it might lapse. So you can draft things in there like your attorney's able to renew it if it lapses, or your attorney's allowed to send it to your estate, but we'd always sort of put something down, well, not necessarily, but you might want to put, they're not allowed to change it. So your attorney's not allowed to change your nomination and direct it to themselves or to, I don't know, another relation. So just another little tip, if you go and have a look at your enduring power of attorney or you're getting a new one, make sure that there's a term or a provision in there that lets your attorney deal with your super.
Okay.
If it isn't, then look at updating it.
Very good point. No, look at finding a new solicitor because they're not doing a good job.
Perhaps.
That was just a plug for you, Anita. That was just a plug.
Perhaps. Okay, I thought we might move on to the exciting bit, the sort of tax bit. But any more thoughts, Mark, on those super nominations in general?
No, look, I mean, the only point is that it's very important to get them done, to keep them current and relevant, and to make sure if you go through any change in your situation, whether you're divorced, you change your relationships that you're in, whatever, just make sure it's a bit like the nominating a beneficiary for your life insurance. Make sure that you keep those nominations up to date. There'd be nothing worse than money going to the wrong person. But yeah, one of the key things in regard to superannuation, obviously, is the tax savings, the tax advantages, and so on. And Juanita, I know you're over this, like you've got it covered. So I will hand over to you to talk about all those advantages, please.
Yeah, absolutely. And look, there's some great resources on our Murdoch's website. And, if you Google, probably maybe not Google, but, if you go on your solicitor's website, I'm sure you'll find lots of fact sheets and information on all this sort of stuff. We certainly do. So I recommend you do that if, there's anything that you want to investigate further after today. But briefly, the taxation implications, I guess, of leaving your super. Now, this gets really tricky, and this is where it's great to have, your A team involved. So a lot of people don't realise that tax may be payable on death on certain components of their superannuation. So that's a starting point.
Do we need a whiteboard?
I wish I did have a whiteboard, but I'll just have to. But I love a good whiteboard. I've got my puppet hands. Now, super is made up of a number of different components, and as we spoke about before, that is one of the things we're looking for when we ask for clients to give us their super statement. So 3 different components is what we usually see. So we have the tax-free component, we have the taxable component, which is taxed within the fund, and a taxable component, which is untaxed. So 3 different sort of terminology there, and they're all treated differently on your death. Stick with me. I'm
confused about the 2 taxable bits, but anyway.
Yeah, absolutely. So I'll give you an example. So the tax-free component, examples of that are personal contributions that you might make yourself to the fund, and certain capital gains tax exempt contributions. So that's the sort of thing that is tax-free. Then we have taxable. So the taxable super, which is taxed within your fund, is the sort of stuff we normally see. So your employer contributions, your salary sacrifice contributions, what's other examples? Personal contributions where there's tax deductions involved. So that's sort of standard. But there's also another component which is taxable but untaxed in your super. And the best example of that is life insurance that's paid to your super. So without getting too complicated, probably the reason that where we're headed here is to understand that, first of all, if your super is left to a super dependent, so that's a spouse, a minor, it's not taxed at all, so don't freak out. But if it is, for example, left to an adult child that's not a dependent, then there will be tax. And how much tax depends on those components I've just talked about. So we can probably make it overcomplicated, but I think the takeaway is your solicitor should be, and your financial planner should be all over the components of your super and whether they're taxable or not, what a superannuation dependent is, because there's taxation benefits in leaving it to them, and the different tax rates and components. Now, if you want to leave your super to adult children, then that's something you're going to have to talk about and look into a little further, because there will be tax on part of your super if you leave it to adult children.
Okay, so can I just summarise there for simple people like me? No matter what the tax components are.
I wasn't agreeing that you were simple, but please do.
I saw you shake your head, but thank you. So no matter what, even if the whole amount is fully taxed, a taxable amount, if somebody dies and that benefit goes to their spouse, for example, there is no tax payable on it.
Correct, tax-free. Yeah. So the questions that you need to be discussing with your estate planning lawyers is, once you express who you wish your super to go to, is there a way to direct your wealth to get the most tax efficiency? They're the sort of questions that need to be discussed, and you should feel quite confident asking about those asking about it and expecting to get some advice around that.
Yeah, and having said that, the caveat is that's a legal word, caveat. That is, unless you need that money to go to a non-dependent, so to speak, one of the adult children or whatever, for another reason to keep it outside of the whole estate plan. Somebody might have a couple of $1 million in their super fund, and they'd rather that went and paid the tax on that to someone who's an adult, not a taxable dependent, and for a reason that might be appropriate at the time.
Absolutely. So again, it all comes down to your personal circumstance, and there's no right or wrong. It's what is best for your circumstance. So it absolutely regularly we might see a client that would prefer to leave their super to their adult children, knowing that will be taxed, because they want to keep it out of that estate for reasons, for example, it might get contested, and that is fine. But the key piece is that you're informed and you're making informed decisions and getting the right advice. tax.
Yep, absolutely. Okay, you have more taxation?
I don't want to give you any more taxation. We'll send everyone to sleep, and I'll see you napping off, Mark. I know it's not your favourite topic.
I'm just looking at the little Hawaiian girl beside your pot plant there, wondering if you take that in your car with you. So that
no, she doesn't go in my car. She came from Honolulu, and I leave her there to remind me that I'll be going back there soon one day, perhaps. Gives me incentive to work hard.
That's right. So let's, I think we've covered the topic pretty well today, unless there's other things you want to talk about. But I mean, let's just summarise the key issues around superannuation funds in estate planning and succession planning. So, you know, my take on it is superannuation is a great way in a tax-sheltered environment for people to be able to accumulate wealth off farm or, you know, outside of their business, and which allows them then when the time comes, it means they've got assets which they can distribute to other children which aren't tied up in the business. So you're not sort of hamstringing the business or putting huge debts against the business if you have off-farm assets. And I'm not saying super should be the only one, but it is one form of off-farm assets. The superannuation taxation issues, I mean, the benefits, I don't know if we even touched on that, but I mean the 15% tax inside the fund as opposed to what you'd be paying outside the fund. So, you know, you've got those advantages as well. What are the key things that? And the third thing I think is the fact that you can you need to have a conversation with someone who's up to speed in this area, so that for your particular circumstance, the way that you structure this, certainly in regard to binding nominations or non-binding nominations, you've done it in a way that's going to create the greatest comfort and allow you to ensure that what you want to happen for your wealth is what happens.
Yeah. So I think, you know, the probably couple of takeaways for our listeners are, one, to know if you have a form in place or not. So a superannuation death benefit form. Check if you've got one in place and check who it's made out to. And then secondly, make sure that you have received the right advice or you get the right advice so it is directed to the right place, whether that is the right place for you, whether that's your spouse, your child, or your estate or another dependent. So, and you understand the reasons why. I think it's simple as that. No one expects everyone, you know, our clients to know all those ins and outs, but if anything we've spoken about today hasn't been discussed with you before, then you really should get some advice on it.
Yeah, one thing we didn't touch on, Juanita, well, in any depth, was insurance, life insurance and a superannuation fund.
Sure,
I know years ago people used to, you know, keep all their life insurance, a lot of their life insurance inside the superannuation fund. A lot of advisors use that as a way of finding money to pay premiums for, to be able to provide good levels of cover for their clients and so on. But there are some, and just quickly, if you can touch on, there may be some disadvantages in having insurance inside the fund if there's a huge payout. Is that right?
Yep. So I suppose the things we're looking for when we're talking to a client about the estate planning and want to know more about life insurance, we're asking, is it in super and is it outside super? Who owns the life insurance policy? Is it the individual or is it the company, or because it's Keyman or something like that? And who is the beneficiary of the life insurance? So there's those three things that we're asking, and depending on the answers will dictate where it goes on your death and what the tax implications are.
Yep. Okay. As usual.
That's a whole other topic. Should we add that to our list of topics?
Next week. We never seem to finish any one topic. But hey, thanks, Juanita, once again. Very valuable conversation in regard to estate planning and the role superannuation, I guess, has as part of that whole situation. And the really, if there's one takeaway more than anything else, it's check who your nomination is to, if you have one, if it's binding, if it's non-binding, and so on. If you can do nothing else, make sure you get that fixed. Juanita, once again, thank you very much. See you in a fortnight, and look forward to chatting with you again then. Thanks for all your wisdom today.
Thanks, Mark. See you then. Bye, everybody.
Bye.